Good afternoon, everyone, and thanks for joining us for today's webinar, HR Compliance Trends to Watch in 2021. I'm Suzanne Sentman, Human Resources Director with McKonly Asbury. For those of you who are unfamiliar, McKonly Asbury is an accounting and business advisory services firm with offices in Camp Hill, Lancaster, and Bloomsburg, Pennsylvania. We provide a range of accounting, tax, audit, and advisory services to many of the region's well-known organizations across a variety of industries. In my human resources capacity with the firm, I periodically assist clients with their HR questions. As we know, employment laws and regulations can be challenging to keep up with. Throw in a pandemic, and well, up-to-date information becomes even more critical to our clients in their day-to-day operations. If you've joined us on past webinars, welcome back. If you haven't, our monthly free webinar series features various business topics to keep you updated on what's going on around us. With COVID, we've held even more webinars over this past year to discuss the ever-changing CARES Act, PPP updates, and more. So be sure to check out our website, including our COVID-19 Resource Center, to catch past presentations and current information through our blog. And don't hesitate to reach out if we can be of help in any way. Today, I'm excited to have with me our guest presenter, Rick Hackman, Chair of the Labor and Employment Group at Saxton and Stump. Rick has over 20 years experience representing employers and management in all aspects of employment law. By coming together today, our firms are looking forward to bringing you the latest on HR compliance trends that we are seeing as we continue into 2021. We encourage you to visit our websites to learn more about what we do and how we can serve you and your organization. Before we dive into today's content, I do want to review some housekeeping items for the webinar. If you have any questions for us during the presentation, please submit them through the built-in questions function in the webinar control panel, and we will do our best to answer them during or after the webinar. For those of you that are looking to obtain CPE credit for today's webinar, please keep in mind that there will be 3 polling questions throughout today's presentation, and you'll need to answer all 3 of those, repeat all 3 questions to get your certificate via email a few weeks after the webinar. Also, as you can see with the fine print at the very bottom of the screen, please remember that today's presentation is general advice only and should not be taken as legal advice. So that being said, once again, thank you to Rick and the Saxton and Stump group for partnering with us today. I'm going to turn things over to you, Rick.
Thanks, Suzanne. And again, I appreciate everyone coming today. We thought it would be a timely subject to delve into today. Several issues that are at the forefront of people's minds with respect to an employment and HR perspective. And the agenda, as you can see on your screen, the employment law enforcement under the new administration, and then we have several COVID topics, which we'll address in order going forward. So with respect to the election impact, some of you may have heard that there was an election recently, and because of that election, we may be seeing some different circumstances and different implications with respect to various employment laws. The prior administration, as many of you know, was very pro-employer. The new administration is essentially going to be very pro-labor, pro-employee. And to date, the actions of the Biden administration have indicated that they're going to aggressively push employee-friendly employment laws and enforcement of those laws, and also promote unions and union organizing. And so essentially, the way to look at this is more or less President Obama's 3rd term. And as many of you remember, during the course of the Obama administration, there was a number of decisions and a number of laws that were enforced by that administration, which have subsequently went by the wayside under President Trump. And we'll talk about a few of those later today. But we'll see many similarities with respect to the current administration as compared to the Obama administration. And in some cases, it may go even a little further.
I think, Rick, we were talking before about the getting out the flux capacitor, right? Back to the Future.
Yes, yes. So get in your DeLorean, flip up the wings and channel your inner Michael J. Fox and, get ready to go back to the future, because that's essentially what we're looking at. So, with respect to specific areas of enforcement, first and foremost is the EEOC, the Equal Employment Opportunity Commission. And as many of you know, the EEOC enforces civil rights laws, Title VII of the Civil Rights Act of 1964 being the primary one. And I also, as you see in the slide, there's sort of a /PHRA there, and that's the Pennsylvania Human Relations Act. And the Pennsylvania Human Relations Commission enforces the Pennsylvania Human Relations Act. And that's somewhat, let's say, coextensive with Title VII, because they're both agencies are enforcing essentially the same type of laws and the same type of issues as it relates to protected categories of individuals in your workplace. So, what are we going to see with respect to these agencies? An increase in filings. Filings were sort of on the downslide the last couple of years. Less harassment filings, less age filings, so on and so forth. The one increase that I have seen during the last 4 years has been claims for disability discrimination. So that seems, with respect to my practice, that's been at the forefront during the last 4 years. I'm not seeing as many sexual harassment cases as I once did when I first started practicing law 25 years ago. There was a lot of sexual harassment cases because that was just sort of the forefront with everything moving forward. You had, Bill Clinton's involvement with Monica Lewinsky, and so it brought it to a forefront. So, and also I would say, in some ways, employers have gotten smarter, or at least I hope they have since then, because back in the good old days, so to speak, there was a lot of just clear instances of problematic behavior. You'd have CEOs, accosting administrative assistants and things like that, and making comments and, making contingencies. If you date me, then, you're going to move up the corporate ladder. You would see more of that. Now you don't see as much as of the overt sexual harassment. But
do you think the Me Too movement has contributed to that?
I think to an extent, I think it has. And I mean, I think that's made a difference. The question is now, is it more subtle? Is it, people are, not as overt, but it's obviously still there. It's still an issue that you need to address in your workplace should it arise, and hopefully it will not arise. As far as the EEOC goes as well, I mean, they may be more aggressive in taking cases. So typically, an employee will file a charge with the EEOC. The EEOC will investigate the case, and they will then make a determination as to whether there's probable cause to believe discrimination occurred. Under either circumstances, whether they find in favor of the employee or the employer, that the employee still has the right to file a lawsuit in federal court. And in some cases, if it's a particularly egregious case, the EEOC itself will take the case on behalf of the employee. So you may see cases out there, the EEOC versus such and such. And I mean, a big one recently was Waffle House. And so they themselves will take the case and prosecute the case on the plaintiff's behalf, so then the plaintiff doesn't have to engage an attorney. I think we'll see more of those with a more aggressive stance with respect to enforcement. And this, when I say more aggressive, it's not, there's not going to be a written directive out there that says, hey, EEOC, I want you to be more aggressive doing this. It's going to filter down through the appointments that the new administration makes. So the appointment, the person who's now heading up the EEOC, her mentality is more aggressive, more enforcement oriented. So that's going to filter down to the people who work for her. And one other mention quickly, as far as with respect to these laws, to whom do they apply? Well, Title VII applies to employers with 15 or more employees. The Pennsylvania Human Relations Act applies to employers with 4 or more employees. So even you smaller employers out there need to be aware that this is something that you need to keep your eyes on. We'll talk a little bit about the Americans with Disabilities Act. In fact, we'll talk a lot about it because it's very related to COVID. Employers with 15 or more employees are covered by the ADA, but it's the same thing for the Pennsylvania Human Relations Act because disability is encompassed within the Pennsylvania Human Relations Act. And so if you're a small employer with 4 or more employees, you'll also be covered by the ADA. And you also have the Age Discrimination and Employment Act, which covers employers with 20 or more employees, or again, the PHRA will cover employers with 4 or more. And just a brief note about sexual orientation and gender identity, which has been at the forefront of the news. Neither of those categories is specifically protected under the law as of now. However, some localities have ordinances which prohibit sexual discrimination or sexual orientation discrimination. Some states do. Pennsylvania does not. The city of Harrisburg does. The city of Philadelphia does. The city of York does. But regardless of whether it's a specific prohibition under the law, courts are now interpreting the term sex, which is found under Title VII, to include sexual orientation and gender identity discrimination. So even though they're not specifically mentioned under the law, there are still cases going up through the system that recognize these as potential categories for prohibited discrimination.
Good point.
With respect to additional enforcement, the Department of Labor is a big one. So just a little stat, I hate throwing stats out there generally, but since March of 2020, with the onset of the lockdowns and everything like that, there's been 1,700 lawsuits filed related to COVID. So those lawsuits, go across the board. Some are retaliation for exercising rights. Some are wrongful termination because maybe an employee said, hey, I don't think you guys are doing it the right way. I don't think you're safe. And the employer says, well, we don't really care, you're fired. Others involve workplace safety, and then discrimination, potentially discrimination against individuals who had COVID or are associated with someone with COVID. And there's also an issue of enforcement of wage payment laws. I mean, are folks properly compensating people for COVID leave? Now, we had the whole Ffcra, Families First Coronavirus Response Act, and as I think we all know, that is now expired, but pursuant to that, employers were required to provide 2 weeks of paid leave to employees who met certain qualifying situations. And in some cases, employers didn't do that. And so now we're seeing some of the lawsuits out there that, hey, I was entitled to this leave, this paid leave, it wasn't provided to me. I was entitled to paid leave under the extended FMLA provision for childcare. It was denied to me. So any number of variations of those type of issues are now filtering their way into the courts. We don't have any definitive case law on anything yet because it is still fresh, but these cases are nonetheless being filed.
And Rick, do you think that because we know that with the Ffcra that did expire the end of 2020, if employers choose to offer those benefits moving forward into 2021, do you think that there is risk for them as well if they do not administer the 2 weeks of paid sick leave, for example, or leave under the the expanded FMLA?
Well, I think there's certainly an opportunity there. Even now, putting aside COVID, putting aside the Ffcra, there are cases out there with respect to FMLA, the traditional FMLA, in cases where employers who were not covered by FMLA, so less than 50 employees, implemented some sort of unpaid leave policy that sort of tracks the FMLA. Hey, we as employers want to be nice guys. We want to set up a system that protects our employees. We'll set up a quasi-FMLA scenario here and monitor it and enforce it and provide the same benefits as FMLA. There are cases out there where employers have gotten themselves in trouble by, courts have said, hey, you're offering what is essentially FMLA benefits more or less to a T. So under the circumstances, you violated it. So you're sort of bringing yourself under the umbrella of FMLA, even though you're not under the umbrella of FMLA. Now those cases are few, but they are out there. So
is that no good deed goes unpunished?
Yes, that's exactly what it is. It's exactly what it is. So with respect to, additional potential liability, there's a number of other issues that folks need to be aware of, one being OSHA, the other being workers' compensation. With respect to OSHA, my guess is we're going to see increased audits and fines. Now, a lot of these, this isn't meant to be a political discussion, but a lot of these laws are based on political whim and based on who's in charge in the White House. And so for the last 4 years, you've seen less, audits and less aggressive enforcement from OSHA, whereas during the 8 years prior, we saw increased fines, increased aggressiveness by OSHA investigators. There's sort of a difference in mentality. I think under the prior, when I say prior, the Obama administration, it was, okay, we really want to make sure employers comply, so we're going to hit them hard with as many fines as we can. Under the Trump administration and the Bush administration prior to that, it was more that we need to work with employers to make sure under the circumstances they are doing things right, but we don't want to put them out of business because it's important to keep people employed. Some other issues, workplace safety is one, and most of those are going to be complaint driven. So you're going to have situations where an employee believes under the circumstances the employer's not doing the right thing with respect to perhaps PPE or sanitizing things or anything else that they're required to do now under the CDC, under the Pennsylvania Department of Health regulations and the CDC guidelines. So you may have instances of OSHA whistleblower actions. So for example, I go to Suzanne, who's my employer, and say, hey, people are supposed to be wearing masks in here and you're not enforcing it and you're not doing the right thing. You're violating the law. And Suzanne says, well, that may be, but guess what? You're fired. So under the circumstances, I'm going to have an OSHA whistleblower action because I went forward with general safety concerns and I suffered an adverse employment action because of that. It's important to remember, and I don't want to get too in the weeds here with OSHA because we have a lot of things to cover, but OSHA itself does not have anything specific regarding COVID and COVID requirements. It all relates back to the general duty clause of OSHA, which requires employers to essentially just keep folks safe who work for them. Mm-hmm. And so there's no specifics other than PPE and everything else associated with that. As far as workers' compensation, again, the duty to create a safe work environment. And we have seen cases where situations where people have filed workers' compensation cases saying, hey, I caught this in the workplace. Because of that, it should be a workers' compensation issue. If it is something someone contracted in the workplace, it's pretty certain the argument is going to be, it's a workers' comp issue. It's not going to be something outside the workers' comp issue. The problem is, and the problem that employees would have in bringing such a claim would be causation. How can they actually show that they contracted in the workplace? I mean, they're at home with their family. They may have gone to see friends. They may have gone somewhere else and run into people. So how can they actually show under the circumstances they contracted in the workforce? Now, it's a little different if you're in the healthcare field, obviously, in your healthcare field and dealing with COVID patients all the time, then the implication is going to be, yeah, well, you probably caught it in the workplace and it wasn't because you were home with your kids. So, I mean, that's sort of in flux right now as to what's going to happen with that. There are some claims under those circumstances. But again, actually tying the two together where it was contracted and whether it was the workplace is a difficult hurdle in some cases.
I was going to just add there, any protections offered to employers? I mean, given that we are in the midst of a global pandemic still.
There were discussions at the state level about that. You know, nothing has happened yet for private employers. I think if anything, it'll be for healthcare employers. But other than that, I think folks are unfortunately out of luck at the moment.
Okay.
So other potential issues going forward, I mean, will the new administration extend the Ffcra? There was discussions back at the end of the last year about this potentially happening. So far, nothing. So maybe it's a dead issue now. Just don't know for sure. Paid leave, and I'll put paid leave in there. There's two things I want to mention about paid leave. First, paid leave in a general sense, unrelated to the Ffcra. I mean, there are bills out there before Congress about providing employees of private employers paid leave. And those have been around for years and years.
Well, even at the state level, right? I mean,
yeah,
we saw that with Wolf, right? Exactly.
And those have been out there for the last 15 years. They've never gone anywhere. However, now on a national level, there's the balance weighs in the favor of the individuals who have been promoting that. So it's a possibility that something like that may come to fruition later this year. As far as paid leave in the Ffcra, we touched on that a little bit, and Suzanne mentioned, well, what if employers continue to offer that benefit? As of now, they can continue to offer that benefit. It's not, not prohibited, certainly not prohibited from doing so. And in fact, you still get tax credits through the end of March if you do voluntarily offer the Ffcra benefit. A couple quick notes. Potential increase in minimum wage. The Biden proposal is bumping it up to $9.50 by July, and then ultimately $15 by 2025. The Wolf proposal is bumping it up to $12 by July and $15 by 2026. I would say the Wolf proposal is going nowhere. The Biden proposal, it's possible. It's just, there's a lot of back and forth with the new COVID bill as to whether that's something that will survive. I could see, and this is just my personal, sometimes worthless opinion, that under the circumstances, the minimum wage may increase. I'm not sure it's going to go to $9.50, but the possibility exists. Maybe we see $8, maybe we see $8.25, or something like that. And then lastly, from a wage standpoint, it's possible we'll see another increase in the salary basis requirement. So if you have exempt employees, currently to maintain an exemption, in addition to performing all exempt duties, they have to be paid at least $684 a week on an ongoing basis, which comes to around $35,000 a year. Some of you may remember the Obama proposal to increase this substantially. So it would have been, if I remember correctly, somewhere in the mid-40s. The bump would have been huge. It would have been, because at the time it was very low. It shouldn't have been a low. It was in the 20s, and essentially it was going to be doubled. Well, that never happened. However, under the Trump administration, it did increase to $35,000 a year. I think the possibility exists that, during the course of the next 4 years, we're going to see it bumped again to perhaps 40, maybe 45. So I'm going to say a few quick words about the National Labor Relations Act. And when I say National Labor Relations Act, a lot of employers will say, well, I don't have a union. This doesn't apply to me. Wrong. The National Labor Relations Act applies to all employers, regardless of whether they're union or non-union. And, what the National Labor Relations Act does is it protects concerted activity by an employee related to their terms and conditions of employment, which include speech. So if you're a private employer, you do have some benefits. The First Amendment essentially doesn't apply to private employers. So I can say something outrageous to Suzanne, and even though if I worked for the federal government, it's something that would be protected speech, Suzanne as a private employer could fire me. But where it gets tricky, and we'll talk about this in a few minutes, is social media comments and terminations. And I'm sort of skipping ahead, but we'll come back to that. So how it works with the National Labor Relations Act is, if I, as an employee, feel aggrieved that my employer did something wrong in violation of the law, I file an unfair labor practice. That goes to the National Labor Relations Board, who then conducts an investigation, and they can potentially order remedies for me in the way of back pay and various other remedies. It could also then go to an administrative judge and work its way up the chain. So the NLRB sets workplace policy through case decisions. So what happens is, at some point after it goes through an administrative hearing, the National Labor Relations Board, there's certain cases that get kicked up to the top level of the National Labor Relations Board that address certain issues such as handbook policies and things along those lines, and we'll talk about that in a minute. But from the get-go, the Biden administration has indicated that they are going to take aggressive steps with respect to the National Labor Relations Act and protecting unions and promoting unions. And I just cited a couple examples there of firing the National Labor Relations Board General Counsel, which is the first time that's ever happened in the history of the country. An appointment of Rosa DeLauro as the chair of the House Appropriations Committee. She's very aggressive in union enforcement and union appropriations, and so she now has the purse strings with respect to money associated with that. And then the new labor secretary is also a former union leader. So these are all things you just have to keep in mind at the environment we're now in.
Right, very pro-union.
Yes. So, and again, election impact on recent National Labor Relations Act or National Labor Relations Board issues. There's been during the last 4 years, there's been a lot of decisions from the board with respect to pro-employer type issues. So an employee versus independent contractor. So the test was changed. It was more streamlined. It made it more clear as to who was an employee versus an independent contractor, because an independent contractor is not covered under the National Labor Relations Act. They are not a protected individual entity person under the National Labor Relations Act. However, the movement is towards eliminating that distinction. So in other words, under this administration, the possibility exists that they may eradicate the difference between employee and independent contractor. So if you have independent contractors that perform work for you, they may also have rights under the National Labor Relations Act. So it's something to consider. Various workplace rules. In the last 4 years, we've gotten some rules whereby, again, more employer-friendly rules. Previously, under the Obama administration, there was a decision out there that said, yes, employees can use their employer-owned email to handle union business, to solicit for union organizing and things along those lines. That was changed under the Trump administration. I think it's going to probably change back. Now, these workplace rules, just quickly, this typically doesn't come down from on high or from some statute. These are all based on case decisions that come before the National Labor Relations Board. So they have to get the right case with the right set of facts in order to come up with some of these changes. The other thing to be aware of is handbooks, certain provisions in the handbooks. Under the Obama administration, the National Labor Relations Board essentially ruled that anything you had in your handbook that could potentially have a chilling effect on employees was unlawful, and it was an unfair labor practice. Policies, there's cases out there with policies, employers prohibiting the use of foul language or not giving people respect. Those were found to be violations of the National Labor Relations Act. Since then, during the last 4 years, that has changed, but we may be going again back to the future with issues like that. So as far as what to do now, sort of practical takeaway type situation, if your handbook was last reviewed, let's say 5 years ago, then a lot of the policies at this point, may be somewhat similar. if it was if it was reviewed in the last 4 years, because if it was compliant with then current law, it's something you may want to revisit and have to take another look at. You know, the problem employers have, and this is an ongoing struggle, is, you know, when are these changes going to happen? We just don't know. So you could go out tomorrow and say, oh yeah, I need to review and revise my handbook. And then a week from now, you may have to make another change. And so it's important to stay on top of the changes, talk to whoever your employment attorney is, you know, stay current to make sure, you know, even if it's a situation where you have to issue amended policies instead of going back through your entire handbook, just make sure you stay on top of it.
And I guess if you curse out loud and your boss overhears you, you're protected, right?
Yeah. Yeah.
Cursing over the handbook rules and things changing.
So social media and terminations. And as I said before, there's been an increased attention to the National Labor Relations Act as far as protected speech. And under the Obama administration, there were a number of cases out there that were brought involving individuals who may have said something on Facebook and were fired for it. And where the line is drawn is protected concerted activity versus mere gripes. So if I get on Facebook and say, oh man, my benefits are terrible, I was denied vacation days, I should be getting a raise, this employer doesn't treat its employees right. If I'm on Facebook saying that, if I'm saying it to myself because I have no friends, you know, which is really the case in reality, but if I'm saying it to myself, it's not going to be an issue. What has to happen is I have to have others involved. So one case that was out there was, you know, had an employee saying something similar to what I just said, and they had a friend there who worked at the company, and that friend gave him the thumbs up. And so that was considered to be concerted because it wasn't just one person, it was, you know, multiple people.
Right.
And then there's the other issue of whether it's related to the terms and conditions of employment or just mere gripes. So if I get on there and just say, Suzanne's a terrible boss, she doesn't like me, I don't like the way she does her hair, on and on, then that's just mere gripes. That's not. And so if I'm saying that stuff, I'm saying she's a terrible boss and, you know, all these other things, then you as an employer can take disciplinary action against me. That's not protected concerted speech.
Right.
And so you need to closely evaluate your policies, what you have in place as far as disclosure of confidential information, you know, violation of harassment policies and workplace violence policies, because you have an obligation to investigate. So let's say, for example, I get on Facebook and I post something that's sexist or racist or something like that, and, you know, actually tie it to the workplace in some manner. Now, you, even if it's just me, if it's not to a group of people, you as an employer have an obligation under Title VII to conduct an investigation once you're made aware of it.
Notice at that point when you're made aware of it?
You are. And so ding, the bell goes off, you're required to investigate it. So the tricky part comes when maybe it's more than one person on the Facebook post as, okay, is this something that violates our policy? You know, weighing them in the balance. Is it something that violates our policies, or is it, you know, concerted activity? And so you really have to tread carefully with respect to undertaking disciplines or terminations at that point. And, you know, my right or wrong, you know, my philosophy with respect to this is that if you have the choice, if you're left with the choice of violating the National Labor Relations Act or violating Title VII, you would rather violate the National Labor Relations Act, because the damages under the National Labor Relations Act are pretty much limited to reinstatement and back pay.
Got it.
If you violate Title VII by not investigating, the damages are much greater. It's compensatory damages, potential punitive damages, attorney's fees, you know, and on and on. So that's a situation where if it's a discrimination issue that you really have to take a close look at, and I would advise anyone faced with that to speak with their employment attorney about it before taking action.
Got it.
And I think we're up to our first polling question.
Yes. Did I go, wait a minute, did I go backwards? Sorry.
Yeah, that's all right.
Sorry about that. So the first question, the greatest employment law concern I have is the new administration's impact, the EEOC and Department of Labor Enforcement. As Rick just reviewed, some of the National Labor Relations Board rulings and activity there. The impact of COVID-19 on employment law, which we just barely scratched the surface on that one, or all of the above.
And we were going to put another one there that says, my greatest concern is continuing to listen to Rick for 30 more minutes. But we limit to what we have.
We were gonna bet. We were gonna take bets here, Rick, right? But I don't know if that would be in violation of any
yeah, no, I think
activity.
Yeah.
What's it going to be? I think there's merit to all of them, really, but that's just my opinion.
Absolutely.
So let's see what everybody said. Interesting. Yep, look at that, 47%. So most everyone said all of the above, but the new administration's impact is certainly in the second or runner-up, right? And then impact of COVID.
All right. Well, speaking of COVID.
Yes, that's a great segue.
Good job. So with respect to COVID and the pandemic, and back to EEOC enforcement, there has been sort of a relaxing of the standards with respect to what you can do and what you can't do with respect to employees and the issue of COVID in the workplace. So the EEOC has long published guidance about the do's and don'ts of what an employer can and can't ask or can and can't do with respect to medical testing, medical examinations, and everything associated with that. But like I said earlier, it loosened up a bit. So some of the things that were not previously permissible under the ADA are now permissible. And there hasn't really been an end date on this. So I guess, it's sort of a wait and see at this point. Do they withdraw this guidance and say, oh, we're going back to normal after we reach a certain threshold and people are back at work or people are vaccinated? I think they probably will at some point. But things now that you're allowed to do that you weren't allowed to do before, you're allowed to ask employees if they're experiencing symptoms. And you're allowed to take their temperatures. Under the ADA, taking an employee's temperature is considered a medical examination, but because of the times we're in, you're now permitted to do that. You can require employees to stay home if they're experiencing symptoms. You can require testing to return to work. I don't have a lot of clients that are requiring testing to return to work. Most of it is just do your quarantine and then come back. I mean, I think initially I had more clients that were doing that, but that's sort of gone by the wayside. And if you are requiring a test, you can't just be the antibody test because the EEOC, for some reason, thinks they're scientists and they say it's unreliable. You may ask all employees if they're diagnosed with COVID or whether they were tested. You can't just target certain individuals. You walk in and you look at me and I look terrible, and you say, you can't really specifically direct it to me. It should be to the entire workforce. And I'm sure most folks are aware, and I'll just throw it out there quickly about the Americans with Disabilities Act, what that protects and who that protects. I mean, a disability is defined in the ADA as someone having a physical or mental impairment that substantially limits one or more major life activity. Pretty much everything anymore is covered under a major life activity. The second way to achieve disability status under the ADA is having a record of such an impairment, and the third is regarding someone as being impaired. So those are the three potential avenues for proving a disability under the ADA. So, I think one of the takeaways here that, from this slide specifically is make sure the supervisors and managers are trained on how to interact with employees. Those who can't report to work, if they're experienced, both employees who can't report because of symptoms and those who are coming into the workplace that potentially may be bringing COVID into the workplace.
Right, and I guess I would just say from an HR standpoint, when in doubt, if you're that frontline supervisor and you're encountering someone, when you agree, Rick, it's best to maybe collect the facts, and even if you have to tell the person, hey, let me get back to you, but make sure you document, you have everything you need, and then talk to whatever the channels are within your organization. You vet it first.
Absolutely, absolutely. Don't shoot from the hip on these things. Make sure you have, all your facts together before taking any sort of action.
Right.
And just a few more, and we'll spend a lot of time on these. Non-permissible still, you may not ask employees physically entering the workplace whether family members tested positive, because it's the whole issue with the Genetic Information Non-Disclosure Act, that this may somehow reveal a genetic disorder, deformity, or something like that. So you can't ask if they're family members. You can say just generally, were you in contact with anyone who tested positive or experiencing symptoms, but you can't specify family members.
And that's more encompassing anyway, isn't it?
What's that?
I said that's more encompassing anyway, wouldn't it be?
It is.
Yeah.
So moving on, you can bar employees from returning if they refuse to allow their temperature to be taken or refuse to answer questions. And as an employer, you can ask reasons for absences. Again, something that while you could get a doctor's note in the past, you really couldn't drill down on reasons for absences. You're permitted to do so now. And you can also ask when an employee returns from travel where the person has traveled. And again, just putting it all together, it's important just to have policies and procedures in place. And so, for example, what we did here, as soon as all this came together and all this came about as a firm, we sat down and we put together the policies and procedures and how we were going to handle these things. Now, things morphed, things changed, and so you have to be nimble and you have to be flexible and you have to be able to adjust. But have something in place to the extent you don't already, to make sure that you're complying with the law and you're treating individuals on a uniform basis. And just a reminder of your obligations in the ADA, and I'm sure most are aware, the information disclosed to you must be kept confidential. Even in information about COVID, you have a situation where you have someone in the workplace who may have tested positive. You have an obligation at that point to talk to those individuals with whom that person may have had close contact, and not necessarily. And I know it's awkward, and it's if you're a small employer, everyone knows who it is, but the way to do it is say, hey, we've received information that under the circumstances you may have been in close contact with someone who tested positive for COVID-19, and you should get tested or something along those lines. You can keep, and I know a lot of employers have individuals when they come in the morning, they scan them and keep a log of their temperatures. That's fine as long as it's not something that's laying on the counter that everyone can see.
Right.
Have someone there, perhaps an HR person, HR capacity, or people have issues in an HR capacity, or some employers have designated COVID coordinators to keep that information confidential. So you can certainly record them in a log, but then you want to keep the information confidential and you don't want to disclose it to every employee. And lastly, you may disclose positive employees' names to the appropriate public health agency. Obligations under the ADA, and we may have mentioned this just briefly, there are individuals out there who are in a high-risk category. However, the ADA does not allow you to simply exclude them from the workforce because your belief that they are more likely to catch the virus. So I know it's tough under certain circumstances. You have individuals that may be immunocompromised, and everyone's aware of it, but you can't simply tell them, hey, you can't come into work because we think you're more likely to catch COVID. Payment for time off. It's no longer, and we'll just be quick about this because it's no longer required for recovery of illness or quarantine because the Ffcra is expired. You can require individuals to use PTO or take unpaid leave under the circumstances.
So your regular company policy could apply at this point.
Correct. With respect to, you have all the issues associated with the CDC versus the Pennsylvania Department of Health versus physician notes. So the CDC's issuances, missives are guidelines and recommendation. The Pennsylvania Department of Health has couched much of their guidance, so to speak, as orders. And then you also have situations where a physician says something different than either the Pennsylvania Department of Health or the CDC says. And so, under the circumstances, you need to follow the most employee-friendly guidelines. Mm-hmm. So if one of these, in comparing the CDC and the PA Department of Health, one benefits employees more than the other, then that's the one that you should be following. As far as returns to work, if you're still part of the whole Pennsylvania essential workforce, then there is more latitude with respect to quarantining and shortened time period for you to come back. And then finally, dealing with physician notes. I mean, I've had situations where, physicians have said that, well, this individual's fine, they don't even need to quarantine. Their contact with this person was so incidental and we tested them and they were negative. The question is, do you as an employer accept that physician's note, or do you follow the CDC guidelines? And you have to look at each one on an individual basis. In most circumstances, my clients have accepted the physician notes, although in an abundance of caution, the quarantining and following the guidelines is probably the better way to go. And I have, I'm going to question here that I saw. I may have missed this, but if you become aware that an employee had an exposure to a positive COVID patient, can you require that they get tested themselves? Yes, you certainly may. If you are requiring employees to get tested to the extent possible, I would recommend that you pay for it, but you're not required to do so. One more here. What is the purpose of keeping a log with employee temperatures and how long do they keep this log? The only purpose is that, and that was just an example, is that if you're a large employer and you have an entrance where everyone's coming in, you want to have a list of employees and be able to write down what the temperature is for each employee. There's no set time period on keeping that. I mean, I would keep it in a locked confidential medical file. At some point it becomes irrelevant. Probably shortly after you take the temperature, it becomes irrelevant.
That's not part of OSHA at all? It doesn't intersect with OSHA?
No. I mean, the only time that your OSHA log compliance issues come into play is if it's a work-related incident. So if someone contracted it in the workplace, yes, you need to include that on your OSHA log.
Okay. There was another question there, quick. I don't know if we have time to address it, Rick. Can an employee that is COVID positive collect unemployment compensation benefits while on quarantine?
Yes, but I mean, if they're on quarantine for now, the reduced quarantine being a week in some circumstances, and there's always a 1 week waiting period for unemployment benefits.
Right.
So it's really almost irrelevant at that point.
Got it. And the backlog that agency has been experiencing, right?
Oh yeah, you're not going to pick up the phone and get someone on the phone right away, right. Certainly. Training employees, and we spoke about this briefly already. You want to document policies and procedures related to COVID, address safety and mitigation measures and expectations in the workplace, and steps and procedures for handling employee concerns. And this is something that should be communicated. Not only your supervisors should be trained in this, but these policies and procedures should be communicated to your employees as well. So people shouldn't be left wondering, well, what do I do in this situation? You should be able to funnel right away to the right person, and the right steps are taken. And, if you are doing this training of supervisors and of employees, get an acknowledgement from them, signed acknowledgement. Yeah, I showed up at, Rick's COVID training and, on February 25th, and sign on the dotted line.
And hopefully this would allay any complaints that employees might have about practices, right? If you're opening up those lines of communication, setting expectations,
yes.
Hopefully you'll head off any complaints or, God forbid, lawsuits, right?
Yeah, and that's exactly right, that someone can't later complain and say, well, I didn't know about that. Well, the question of the deposition then, well, you see this document in front of you? Yes. Is that your signature on there? Yes. Is that the date you signed? Yes. Well, you were there when the training was conducted on this? Yes. And then you'll typically get the question, well, I wasn't really paying attention or something. That's tough. You went to the training, you signed the document, you indicated you understand, and we're going to comply with this, but yet you didn't. So I think that leads to the next exciting polling question.
It does. It does. So polling question number 2, my organization has adequate policies and procedures in place for maintaining a safe workplace during the pandemic. So tell us what your thoughts are there. Do you strongly agree with that statement, or do you strongly disagree and you need help? Again, we'll place some bets, but I think the biggest hurdle, just from the HR lens of things, I don't know if you can weigh in on this, Rick, but just the change, just when you think you understand something, things change or shift. Yeah,
and I would say if this question had been asked 6 months ago, the answer would be substantially different than what the answer would to be now, or at least I would hope what the answer is going to be now. And I would think as of now, we get a lot of somewhat agrees. 6 months ago, we might have gotten somewhat disagrees. So, and it's time. It's implementing procedures, people becoming more familiar with what's out there and what's at issue, and going from there.
Right.
Good.
That's awesome. That's great news. Okay, so I know it's 2:52. We're ending at 3. We've got, I know, one more polling question to get to, so we will continue moving along.
Yeah,
so employee complaints.
Yeah, employee complaints, and the highlight underscore there is need to tread carefully, investigate the issues raised, and confirm compliance and not retaliate against that person. And I recently had a situation where the dentist's office and had an employee who was constantly complaining about, well, you're not doing this right, you're not doing that right, you're not following the CDC guidance, you're not following the Pennsylvania Department of Health guidance, when in fact they were doing everything right. And the Department of Health came in and investigated the employer. The employer got a clean bill of health. They were doing everything right. This employee continued to stir up trouble in the workplace, and some of it involved insubordination to her superiors, but trying to essentially freak out employees that things weren't going the way they should, even though the Department of Health cleared them. So situation there where the dentist office can't have this person disrupting the workplace on an unjustified basis. So you really have to take a close look. Well, how can we tie this to the insubordinate behavior versus the complaints about our health practices? And under those circumstances, you can discipline someone if it's in fact disruptive to the workplace. I mean, even if someone brings a complaint and it doesn't have merit, like this one did not, they are still somewhat protected from retaliation. So, I mean, if they bring a bad faith complaint, a malicious complaint for no reason, they're not going to be protected from retaliation.
Yeah.
And
so we're going to shift gears and talk a little bit about the vaccine and some concerns that employers may have with regard to that and employment law. So just a curiosity here, does your organization require the COVID-19 vaccine in order to return to work? Again, this is the last question in the series for you to get your CPE credits for those of you that are interested in such. So please be sure to answer the question.
And I will tell you, with respect to my practice, it's been a mixed bag. Now, I do have, some employers who are requiring the COVID-19 vaccine. A number of them are long-term care facilities. On the other hand, I have clients who've said, no, we're going to encourage folks to do so, but we're not going to require it. So it's been, really a mixed bag from my perspective.
And the results are in. So, wow, it looks like a resounding no is what we're seeing. But then some folks haven't made a determination yet. And I kind of feel like, lucky if you can get your hands on that vaccine, right?
Exactly. So, I mean, the question, it looks like 63% of the attendees have already made this decision, but as far as whether you can mandate it, you can absolutely mandate it, but subject to a few exceptions. One is a sincerely held religious belief. The other is a disability. If you are mandating it and someone raises one of these two issues, you as an employer have an obligation to reasonably accommodate that person unless it's an undue hardship. Now, in the past, when we've had situations with the flu vaccine where people did not want to get the flu vaccine, but it was mandated, one of the reasonable accommodations was, well, you have to wear a mask. Well, everyone's wearing a mask now anyway, so that one's sort of gone by the wayside. So even people who are vaccinated in the workplace are generally wearing masks. So it's unclear at this point what a reasonable accommodation would be unless you have some place you can stick someone with no staff contact or client contact, custodial closet or something. But, under the circumstances, it's a difficult subject. But as indicated by the poll, it doesn't seem to be an issue that a lot of employers are going to confront because they are not going to mandate it. Simply not trusting the vaccine is not a valid reason for exemption, although there are, on both sides of the aisle here, with respect to whether the vaccine was rushed, whether it's, necessary, do we know enough about it, all those type of things, all of which are valid concerns, but they're not valid reasons to exempt themselves from a mandate with respect to vaccination. And as far as if someone does request an exemption, you can request information from the doctor regarding a disability. However, if it's on a religious basis, you really can't request any further information. You essentially have to accept someone's word on that issue. And this is all, again, with the backdrop of the Americans with Disabilities Act, because that's why we have these exceptions here for the most part. And there's been a lot of talk recently, can employers provide incentives to get the vaccine? And people have been asking the EEOC to issue some sort of guidance on this, because you may remember the EEOC had issued guidance in the past on wellness programs and whether you can offer incentives for people to join wellness programs. And they extremely limited the ability of employers to offer incentives for wellness programs. It has to be something nominal, like a water bottle or a keychain or, a $5 gift certificate to Sizzler or whatever you decide to do, but it can't be something substantial. So if employers want people to get the vaccination in the workplace, the best way to go about it is through education. Provide the information that's out there saying, well, this study says this study says this is what's safe. We believe under the circumstances it makes sense for our clients, our customers, our patients to have you vaccinated, and for your own safety and for the safety of your family. And so there's got to be, you should establish someone as, again, sort of the COVID vaccination guru that people can go to with questions, or that person can communicate, to individuals, the thoughts and the thoughts of the organization, and the benefits of getting the vaccine.
Good points.
So we're right at 3 o'clock. Just in conclusion, and we've covered a little bit of this already, get your practices and policies in place. Make sure they're applied equally to all employees, and train your managers and train your employees. And that's really the most important part. Make sure those in the workplace are educated about what their obligations are and what their rights are.
Very good. And the other thing too, I would just point out, I feel like there's an overarching theme here of you certainly don't want to be seen as retaliating against your employees, right? For if they raise concern, Rick, they have questions. I kind of go back to the communication and training portion, right? To make sure that everybody has those avenues. If they have questions or concerns, they can express themselves, go to somebody who's trusted within the company. But of course, you don't want to be seen as, being retaliatory.
Yeah, absolutely. Absolutely.
So, okay. Well, I don't see any other questions that have come in at this point. Oh, whoops. Can I poll my employees to ask if they plan on getting the vaccine when it's available?
Yeah, I see nothing that would prohibit you from doing so.
Okay. Okay. Another question here, if an employee has a family member that has tested positive and wants to take a day off, this is the employee's suggestion, does this count as a sick day? I guess a company paid or use of a sick day.
Well, that would be governed by your policy. What does your policy say? Are you allowed to take days off for care of a family member? So that would just strictly be governed by your own internal policy. Sure.
Okay. Okay, so with that being said, I don't believe we have any other questions, and we totally are at, we're over our 3 o'clock time at this point. So I'm going to wrap things up here. On behalf of McKonly Asbury and Saxton and Stump, thank you for joining us for this webinar. If you have any further questions regarding today's presentation, please feel free to reach out to one of us and we would be happy to assist. As a reminder, a recording of today's presentation will be posted on our website and social media sites in a few days. And for those of you who requested the CPE and answered all 3 polling questions, very important, those certificates will be sent out within the next 2 weeks. So thank you, Rick, for joining us on today's webinar, and thank you, everyone. On behalf of McKonly and Asbury, we look forward to our next webinar with you, so thank you.
Thank you.